There we go. Okay. Hello, everyone, and welcome to Ditch Diggers Dialogue Volume 13. My name is Ashley Hudson. I'm the Operations Manager with the Heavy Construction Contractors Association. If this is your first time tuning into a Ditch Diggers Dialogue, welcome. HCCA strives to provide educational and networking opportunities for our membership, so we created this Ditch Diggers Dialogue series as a virtual way to stay connected. Today, you will hear from Joe Casimir, who has over 45 years of experience with construction contract claims, and Emily Blake, associate at Rees, Broome. During today's session, we ask that you keep your microphones muted until we open the floor for questions. If you do have questions or thoughts as we move through the presentation, I encourage you to type them in the chat box as we go so they can be addressed at the end of the presentation. Before I turn the floor over to Emily and Joe, I would like to make an announcement that our networking happy hour tonight from 4 to 6 at Chantilly National Golf Club on Braddock Road is going to happen rain or shine, and we would love to see you all there. So now I will turn it over to Joe and Emily. Thank you both for being here, and the floor is yours.
Okay. Well, good morning, and we're pleased to be able to put on this presentation for you on a topic that I think is going to become something you're going to hear more and more about, as you're going to see as we go through. Let's go to the first slide. Let me tell you a story first of all, to start with. Let's suppose you were running some kind of a plant, a concrete plant or an asphalt plant, and you have an employee who's in charge of running that plant and making sure that your mix that you're producing matches the job mix formula that's required. Well, this employee doesn't do a very good job and makes lots of mistakes and doesn't pay attention. And many times your job mix has turned out not to be correct. You told the employee many times that they need to do better. They don't do better, and you fire the employee. The employee then decides that he's angry at the company for being fired. He goes to a government body that you've been doing work with and tells them, instead of the truth, which is that he's been screwing up the mixes, he tells them that he was directed to change the mix by the ownership of the company. Well, if that happens and the government takes an interest in the case, they could possibly make a claim against you under certain laws that we're going to discuss in a minute. And if that happens, what's your liability? That you'd have to pay damages, that the damages might be tripled, that there's a statutory penalty of between $11,665 and $23,310. And that's, next slide, that's for each false statement. So if you submitted, let's say, mix certifications 100 times, that could be 100 false statements. You could even be sued by this employee who's lying on behalf of the government, in which case you could even be responsible for the costs of suit, and you could be suspended or debarred from further government procurements. If this sounds like a nightmare and something that can't be real, unfortunately, I have to tell you it's true, and it is your worst nightmare if it comes to pass. And we're going to talk about that today and discuss what goes into a False Claims Act. And also, we're going to give you a bunch of examples of things that have actually happened in the last few years. This is not some theoretical problem. This is a very real situation that involves huge amounts of money, as we're going to see. Now, all these liabilities relate to government contracts, and the federal one is the one that you see the most, and that's the Federal False Claims Act, and we've given you the citations. There's one for civil liability, there's one for criminal liability, and there's one for that prohibits you from retaliating against an employee who might have blown the whistle on you. Well, you might say, well, I don't do business with the federal government. I'm not worried. Well, Virginia, Maryland, and DC all have their own False Claims Act. So if you do any work with a government body, and that would probably include any project that's funded by a government body, you have potential liability. The Virginia, Maryland, and DC differ somewhat from the federal, but they're basically along the same lines. We're going to mostly talk about the federal today, but you should just keep in mind that Virginia, Maryland, and DC all have their own statute that you could be liable under. For example, in Virginia, anytime you submit a claim to the Virginia Department of Transportation, you're required to sign a certification at the end of that claim that says that nothing in this claim is known to be false, and if it's found to be false, I'm going to be liable under the Virginia Fraud Against Taxpayers Act. Every single claim submitted to VDOT under their claim procedure contains that certification and opens potential liability for people who might exaggerate intentionally their claims. So let's go to the next slide. There's 4 elements to a False Claims Act violation, and Emily's going to discuss those 4 elements, and she's going to discuss a little bit about each one and what it makes up, consists of. So Emily, go ahead.
Hi, good morning. So anytime the government wants to bring a false claims action against you or your company, they have to prove 4 elements. We're just going to briefly discuss those 4 elements before Joe gets into the examples of everything. So it's false statement, knowledge, materiality, and request for money. The first element is false statement. So essentially, if you submit any claim to the government or you cause anybody else to submit a claim to the government, or you make a false certification, as Joe was just discussing with VDOT, or you even conspire with others to try to violate the False Claims Act, those all fall underneath the definition of what a false statement is. It doesn't necessarily have to be a literal statement. It can be, like we said, a certification. So anytime you submit any kind of certification to VDOT or to any governmental entity, if you're certifying that your wages and hours for your employees are correct, anything like that, that's going to be considered a false statement if it is in fact false. We've provided this statute here just in case if you wanted to take a look at it. I'm not going to read it to you, but I've previously summarized the definition, but here it is, the actual definition for your knowledge. Speaking of, the second element is knowledge. So there's 3 different types of knowledge. There's actual, deliberate ignorance, and reckless indifference. So you don't have to actually know something in order to be held liable under the False Claims Act. It's this interesting little legal theory where they're like, well, if you could have known, you should have known. And if you could have known, then we're going to say that you violated the False Claims Act. So some examples, actual knowledge is, of course, I know my employee makes $20 an hour, but I submit a change order with a salary of $30 per hour. That's actual knowledge that you are submitting a false claim to the government. There's deliberate ignorance. Your employee is concerned and he comes to you and says, you know, I have these concerns that the cement mix isn't 100% correct. You're like, I don't want to hear about it. It's close enough. That's deliberate ignorance if you decide to not go out and check to see, you know, how the cement is mixing. Then lastly, you have reckless indifference. So for example, a subcontractor submits a change order to you, and that change order shows that the price of a material is $100 per unit. You've bought this same product hundreds of times for only $20 per unit. You don't know why this subcontractor has to pay $100 per hour, and you don't ask, you don't inquire further, you just submit and forward the change order on to the government. This would be reckless indifference. And we'll kind of cover this a little bit more, but it doesn't even matter if it's not even your own false statement that is submitted to the government. If the subcontractor comes with you with a statement and you take a look at it and it smells kind of fishy, kind of stinky, but you don't inquire any further, and then you submit that change order or what that certification, whatever it is, onto the federal government, that is you presenting a false claim to the federal government, despite the fact that it is not necessarily your false claim. So, material. Essentially, it is very easy for the court or for the government to prove that a false statement was material to the government's decision-making to pay out on this false claim. Basically, did it influence the government's decision to pay? Would a reasonable person consider it material? And I'll show you an example in the next slide as to what material or whether a reasonable person would consider it material. But you guys are all experts here. You guys all know that when the government says that they want X, what you need to provide in order to meet that standard. And so here we have an example. If the government is procuring guns, but does not specify that the guns must actually shoot, it is still a material misrepresentation to supply guns that do not shoot, because a reasonable person would realize the imperative of a functioning firearm. If the industry standard is for, all widgets that you provide to have functioning gadgets, then, that's industry standard. And you guys know that because you guys have been in the business for, however many years. So materiality is just very easy to prove. The last element is claim. Again, the definition of claim is very, very broad. If the action you take impacts federal money in any way, it is probably a claim. Again, we're talking about, if you certify anything, if you cause money to be paid from the government, if you cause money to be paid to your subcontractor, those are all claims. Essentially, if you make a statement to any federal government or anyone or any company who is working with money from the federal government, you better watch out. And again, here we have the claim statute. And to reemphasize, pretty much all states have their own False Claims Act or version thereof, and that applies to local government as well. That kind of filters down. So no matter what governmental entity you are working with, if you submit a false claim that is material to the government's decision to pay, and you had knowledge or some form of knowledge of that claim, then you can be held liable under the False Claims Act. Long story short, do not lie, do not misrepresent any fact, no matter how small. Triple check everything you sign, including documents given to you by subcontractors. Again, it does not matter if it is your statement or your claim. If you pass that claim along to the governmental entity, then you can be held liable as well. And to reemphasize, this is either you or your company or both. The government and the statutes, the way that they're designed is that the government can go after either an individual or the entity or both. So you just want to make sure that you take all of this very, very seriously, because I don't know how much you guys have saved up, but you'll see from the examples, individuals can be hit hard by these statutes. So if you are in a position of power within your company or you have any kind of decision-making ability, you could be hit individually as well. And I believe Joe is going to jump in here. Joe, you're on mute.
Okay, so what's the risk? And the risk in this is frequently grossly out of proportion to whatever the company did wrong. First of all, violators, which includes individuals, as Emily pointed out, you're liable for a civil penalty that runs between $11,665 and $23,331. So that's even if the government can't show any real loss, you're still going to be in that range. It's very interesting that this penalty amount used to be relatively smaller, much smaller amount, but it has been increased continually up to this point, and I'm sure that this year, or actually this is this year's, but I'm sure next year it's going to be even higher. So you'll see in one of the examples we have that I think there's no actual damage, but they end up paying over a six-figure penalty for the violations. So that's the first thing is the statutory penalty. The second thing is you have to pay 3 times the amount of the actual damage that the government suffers. So if you overcharged, $30,000 on a change order, you're going to not only pay back the $30,000, but you're going to pay 3 times the $30,000 plus the statutory penalties. And that's for each false statement. So let's say suppose that you've submitted false certified payrolls. Well, you could have submitted, 50 or 100 certified payrolls on one project. So that's for each false statement. If the government files suit, the violator is liable for the costs of bringing the suit. And then, of course, you're probably going to be suspended or debarred as a result of a false claim. So this is serious business, big money, as you're going to see in a second. This isn't some minor problem that is going to go away. If I underpaid one of my workers, I'll just pay him and it'll be fine. As we're going to see, it's a lot more serious than that. So let's go to the next slide. So let's talk about the process for a second. Who can bring one of these actions? Because if it doesn't get settled, it would be an action that's brought in court. And the Attorney General, and this is for federal, if it's a state, it would be the Attorney General of the state, but let's stick with the federal for a second. The United States Attorney General, the Department of Justice would bring the suit. To give you an idea of the kind of numbers that are involved in this, in 2019, the Department of Justice collected more than $3 billion, that's with a B, billion in settlements and judgments in 2019. I mean, that's a staggering amount of money. There were 786 False Claims Act suits brought in 2019, of which whistleblowers filed 638. Of the 922 false claims suits that were brought in 2020, last year, whistleblowers filed 672. So if we go to the next slide, let's talk about how it works. So there's 2 ways that you could be sued on this. If it comes to the government's attention directly through the government, let's say its own people establish that there's something fraudulent going on, they involve the U.S. Attorney's Office, they can simply bring this case forward, use their power to get your records, either force a settlement, and if that doesn't work, they can file the suit directly. So that's one way it can happen. But the second way is, I think, much more concerning and much more unique, and that is a private person, which would include an employee, could file a suit. And what they do is how it works is the individual, let's say it's this disgruntled employee that I talked about at the very start. The disgruntled employee says, they told me to falsify the cement content, even though that's a complete lie, okay? So he gets a lawyer, they prepare a lawsuit, they file it in federal court, but it's filed what's called under seal, which means it's hidden and it's not part of the public record. And they don't serve it on the defendant, but they notify the Department of Justice that, hey, I just filed a False Claims Act suit, and are you interested in taking the case yourself? So the Attorney General has two options. They can take the case themselves, or if they don't take the case themselves, they can tell this whistleblower, fine, you go ahead and you go ahead and you proceed with it yourself. If the government takes over the case, it's called a qui tam action. And if the government does take over the case, then, and they're successful, the private person who told them about it and filed the suit under seal that the government then took over can get up to 25% of the recovery, which could be very, as you're going to see, can be a tremendous amount of money for an individual and his lawyer. If the government doesn't take over the case and says, no, we're not interested in that, the private person can proceed with the case on their own, and they're entitled to keep up to 30% of the money collected that can be proven in the case. To show you, give you an idea that this is a big money and big deal, in 2019, whistleblowers personally collected over $365 million. In 2020, whistleblowers personally collected a little over $309 million. That's just their share of the recovery. So, that gives you an idea that we're talking about big money here. This is not small potatoes, and it's a significant problem. Next slide. Now, if you have an employee that you think is blowing the whistle on you, you're not going to be very happy about it. And you're going to want to fire them or demote them or do something. And the short answer to that is, if you do that, you're running a huge risk, because the way the statute's written, the False Claims Act has a specific anti-retaliation statute that governs this. So if a whistleblower is involved in basically getting ready to destroy your company, you cannot retaliate in any way. And retaliation is a general term. It includes discharging them, firing them, demoting them, suddenly giving them poor performance reviews, threatening them, and things like that. And it's very, very easy for the employee to make a case if something negative happens after they blow the whistle. It's very easy for them to make a showing that they were retaliated against. And what can they recover? Well, if you fired them, they can get reinstated. Just what you wanted was the employee that you fired back working for you. You have to pay them double back pay that they didn't get if they were fired, or if they were if their salary was cut. You may have to pay their attorney fees, and you may have to pay any special damages that they incur. So, next slide. It doesn't even matter if the employee's correct, as long as the employee actually believed that there was some kind of fraud ongoing. You can be found liable, and that would include individually. So should you start receiving complaints, comments, or concerns from your employees that there's something going on, that somebody's making false statements, false certifications, something's being done improperly, you need to contact an attorney immediately to discuss it, because you're on very slippery ground at this point, and you're going to need to be very careful in how you handle it, both from an employment standpoint and also in terms of your relationship with the government body that is involved in that particular project. So We've included on the next page, the anti-retaliation provisions, just so you can read it. And by the way, if anybody wants these materials, if you would just email either me or Emily, we'll be happy to send a copy of the materials to you. So let's go to the next slide now. We're going to start covering a few examples of what can happen. And these aren't things that Emily and I made up just to scare you. These are all real, documented things that have happened, that have been publicized by the Department of Justice, because they love making these announcements. You know, they have these press releases to announce that they're taking certain actions, or a press release that they've recovered money from somebody. They just love doing that. So let's take the first example. This is a case out of Indiana. This company, Dave O'Mara Contractor, Inc., misrepresented that it's the materials that they were paving roads on federally funded projects in Indiana. They misrepresented what was in the mix, basically. They claimed that the mix met the Indiana DOT's required minimum amounts for binder that would hold the mix together, but they frequently failed to meet the minimum standard. They also misrepresented that they were using slag, which they were not, which they were saying to hide the fact that they needed to use more binder, and they weren't. The case settled for $4.25 million. And this contractor was not a giant company. They had a bunch of affiliated companies, and this $4.2 million had to be paid over the course of 4 years. And everybody involved, owners, affiliated companies, they had an equipment company, I think, and several different companies, they all had to sign on to this settlement agreement, and all had to agree that they were going to be responsible for this $4.2 million in payments. That's a lot of money for a contractor, especially one who's not gigantic. So this was actually the case that first got my attention about this. I noted it through the Virginia Asphalt Association, and it got me inquiring about what else was going on, and that's what got us started on this seminar. Let's look at our next example. Okay, this is a case where the parties tried to take advantage of a veteran-owned small business set-aside. Northland Associates was the prime contractor, and this Diverse Construction Company was a service-disabled, veteran-owned company. There were set-asides for the service-owned small businesses, and they wanted to get on the contract. Diverse was 51% owned by a service-disabled veteran and 49% owned by Northland Associates, who was the prime contractor. Now, that alone is not disqualifying. It always raises a question, but it's not disqualifying. But what the government found was that the prime contractor, Northland, which was not a service-disabled veteran-owned company, was really in charge and in control of Diverse, the service-disabled company. Examples: Northland put its own people on Diverse's payroll, had Diverse re-subcontract back to Northland. So essentially the work went from Northland to Diverse back to Northland. And they handled all the accounting, all the estimating, all the purchasing, all the contracting, and all the clerical work for Diverse. Essentially, Diverse wasn't doing anything. They were just, you know, a storefront, window dressing. So if you go to the next slide, the government found that the companies were actually affiliated, and therefore, because of that close connection, when the companies are affiliated, you know, they exceeded the small business set-aside requirement. So it was all considered to be a false, multiple false statements. The case settled for $4,470,000. One interesting little sidelight in this case is that the bonding company's agent ended up having to pay a part of the settlement. And that's because apparently the bonding company agent knew that this arrangement was not a real arrangement, but was a sham arrangement. And there's a party who's not, you know, not even directly in line with the government that's being sucked into this and ending up paying because they had knowledge of what was going on. So that's an easy example, but one that had a big price tag on it. In a similar vein, our third example involves Ducci Electrical Contractors who got a federally funded contract with the Department of Transportation. That contract required that 13% of the work was to be performed by disadvantaged business enterprises. Not unusual. That's pretty common on any federally funded project. So Ducci told the government that company number one would fulfill the DBE requirement, except that there was a small problem, which was that company number one, the DBE subcontractor, never actually performed any commercially useful function. You know, examples, and this is a little bit like the previous case. So Ducci puts an employee on company one payroll, their own employee on company one's payroll. They supervise company number one's employees, and they tell company number one, here's how many hours the employees worked for billing and payment purposes, gives the DBE Ducci-owned equipment to do the work with, negotiates and orders the materials for the DBE subcontractor for the project. You know, again, clearly the sub is not performing a commercially useful function in this case. It's strictly a front, really, for Ducci. They get caught at it. They have to settle for a period of time. So again, this is more than just I didn't make my DBE requirement, so I have to deal with whatever fallout comes from that. This is I didn't make my DBE requirement, and it cost me $3.2 million. Okay. False estimates, knowingly false estimates, are a whole separate problem. In this case, a former vice president of the contractor was the person who got this False Claims Act started. And that former vice president alleged that the contractor had submitted false information to the Department of Energy in order to allow the contractor to subcontract part of their work. Essentially what happened is that the contractor wanted to subcontract the work. There were restrictions on subcontracting. So the contractor said, oh, I'm only going to subcontract, pick a number, 5% of the work to this subcontractor. And after they asked for that, DOE approved it. So in reality, the subcontractor performed way more than 5%. And this former vice president knew that the company knew that it wasn't going to be 5%. It was going to be a lot more than that. Based on this, the Department of Energy approved the subcontract. When the False Claims Act was filed, what the government then wanted was they demanded recovery of all payments made under that subcontract because it was all obtained based upon a false statement. One of the quotations out of this case, and it's actually a case out of the Fourth Circuit, which is the one federal government appeals court covers this area, where the court said an opinion or estimate carries with it an implied assertion, not only that the speaker knows no facts that would preclude such an opinion, but that he does know facts which would justify it. So this former vice president, I guess, couldn't prove any actual damages. I'm not quite sure why. It may have been that the government still would have had to pay the money, but it still didn't matter. The trial court awarded $7,500 for each of 51 violations, which I assume was 51 pay applications put in that related to this subcontract. So at that time, the penalty was less, $7,500 for each violation, for a total of $195,000. And that's with no damages. That's just the statutory penalty, which today would be at least $4,000 a violation higher. And the former vice president, who is the whistleblower, which in False Claims Act language is sometimes called the relator, got $58,000 of the money. So again, this is something where the fallout from it was probably way in excess of what there was to be gained. Let's go to number 5. Oh, this is my favorite. So the Fairfield Company was an electrical contractor, and they were doing electrical work on a government project. So they told their foreman, well, you go ahead and you use the people out on the crew the way you see fit. So this is, of course, is a wage rate project, and electricians got a certain wage rate, and then laborers got a way lower wage rate, not unusual. So what the foremen were doing was they had people who were really probably doing electrical work, but they kept classifying them as laborers. And of course, they're submitting certified payrolls, right? And this comes to the attention of the International Brotherhood of Electrical Workers, Local Union 98. And they, after getting wind of this, goes ahead and files a False Claims Act suit on their own, saying that they're not paying electricians wages. And Fairfield tries to say that, well, I didn't know because we let our foreman take care of that. Well, that defense didn't go anywhere. The court found that Fairfield acted with reckless disregard for the truth or falsity of the information, mostly by allowing its foreman to decide what the workers did without regard to classification, despite Fairfield's awareness of the prevailing wage obligations. In other words, just telling your foreman, well, you guys go figure it out, was not enough to get them absolved from liability. So the trial court awarded over $1 million in damages in this case. And to add insult to injury, $316,000 of it was awarded to Local 98, plus $1.4 million in attorney fees that they had incurred in prosecuting this case. And the actual case decision is interesting because Farfield keeps trying to say, well, you know, that kind of work's really labor work. And the union saying, oh, no, 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 you know, you can't pull wire, you know, and be a laborer. That's strictly electrician's work. So it was an interesting case, but the union certainly got the last laugh on this one. Okay, next. This is a where is it? This is a case that's pretty recent. This was a news release from February of 2021, just 2 months ago, less than 2 months ago. And in this case, there was a concrete contractor who was providing concrete to construct Navy airfields in the Middle East. And they had a job mix formula for the concrete, which they didn't fulfill. And apparently, knowingly, they provided non-compliant concrete that did not meet the gradation requirements. It contained excessive alkali silica reactive material and contained elevated chloride contents. So because of that, you know, not only, you know, was the mix that they presented an incorrect statement because what they gave them wasn't that mix, but because of those deviations, it was found that this could cause problems such as early age cracking, surface defects, and corrosion of the embedded steel, and therefore it wouldn't have the long-term durability it was supposed to have. So this case was settled for $3.9 million. But while it's not on this slide, that is not the end of this story. Because believe it or not, it gets worse. The government also went after them criminally and ended up with a deferred prosecution agreement where this contractor ended up paying $12.5 million monetary penalty, which was a fine, forfeiture, and restitution. So a little bit of this, like 1.9, was credited towards this civil settlement of 3.9, but the balance of the 12 had to be paid by this company. So the bottom line was that having a fraudulent mix cost them over $14 million. So, and this is a very recent case. So, you know, the government plays for keeps when they have these cases. Next slide. This actually involves a government contractor that is Virginia-based. And this came out, it was a press release February 19th, less than 2 months ago. This Virginia-based company called Triple I Creative Computing Solutions I believe they bought them in 2015. They ended up liable for false claims made by the company they bought. And what had happened is the original company, there were certain requirements for the employees in terms of their ability to perform certain jobs. They hired people who did not meet the qualifications and billed the government for the underqualified personnel at the higher rates that were reserved for more qualified people. They got caught doing it. The acting U.S. attorney in Maryland said defense contractors are required to bill for costs actually incurred and to be truthful in the claims that they submit to federal agencies. Case was settled for $6 million. So, that's something that happened right around here. Now, what's not clear to me is it's possible that the purchaser knew that this problem was there, and maybe they had reserved money, or maybe the original company was still responsible for it, or maybe they just got a really unpleasant surprise after they purchased the company. So, word to the wise, if you're purchasing a company, you ought to be thinking about what other liabilities they may have, and be sure you've got that covered. Let's see, next slide. Okay, there are some areas that I think are likely, and we're going to see not only likely, but real areas. When we first prepared this, we felt that COVID relief funds were going to be a place where there are going to be a lot of false claims. Also, Buy American Act compliance, because President Biden has made an executive order saying that Buy Americans compliance is going to be a priority. And there's been a lot of displacement of employees because of the COVID that increases the number of potentially disgruntled employees who are looking for a payday. Now, Emily's going to discuss next a couple of more recent things that have happened that show where this can go. So, Emily?
So as Joe was saying, we originally made this slide deck early January. And so in order to prepare for today's presentation, I went online and I was like, okay, so what's going on with the federal government and COVID relief funds? Turns out a lot. So first of all, the government is openly inviting people to report COVID-19 procurement collusion by email. They want to make it as easy as possible for your former or current, or literally anyone you've ever worked with, employees, coworkers, colleagues, to report any kind of fraud that they can prosecute under the False Claims Act. They, put it, this is their homepage. They're ready to go. The Justice Department has, in fact, publicly charged 474 defendants with criminal offenses based on fraud schemes. They have, this is with a lot of the fraud schemes have to do with, your obvious, very unscrupulous people who lie to get PPP loans, but it's also something very simple as, people who kind of inflate their payroll expenses in order to obtain larger loans that they would have otherwise qualified for. So the example that's a little bit more fun and probably won't actually, hopefully, apply to anybody in this particular group here is the defendant applied for 15 different PPP loans to 8 different lenders using 11 different companies, seeking a total of $24.8 million. The defendant obtained approximately $17.3 million and used proceeds to purchase multiple homes, jewelry, and luxury vehicles. So obviously that's not really hopefully going to apply to most of you. Hopefully most of you are not criminal masterminds. But it is kind of showing that the government is taking a look into this. And so they're going to catch the easiest people to catch first, like this doofus, who took out multiple loans for multiple different fake companies. It's easy to run that stuff down. But it just goes to show that the Department of Justice is throwing a lot of resources behind prosecuting any type of fraud when it comes to these COVID-19 funds. The government's been paying out millions and billions of dollars. It wants to make sure that it's being used appropriately. And, it's not just the PPP loans, it's the economic injury disaster loans that came out, and it's the unemployment insurance fraud. There's a lot of unemployment insurance fraud claims that are coming out. And, the article is saying domestic fraudsters ranging from identity thieves to prison inmates have committed unemployment insurance fraud. But once again, the government, of course, is going to go after the easiest criminals first. And then once they start looking into all of this, they might see these contractors who, like over here, prosecuted individual business owners who have inflated their payroll expenses. Something as easy as that can become a red flag when it comes to COVID-19. And again, they want to make it as easy as possible. And as Joe was saying on this previous slide here, when it comes to who reports False Claims Act violations, a lot of times it is former employees. And what do we have more of last year and this year is former employees. A lot of people displaced because of, cutbacks and companies closing. So you just want to be extra careful now more than ever because, the government sees the utility of prosecuting False Claims Act because it obviously can get a lot of money from it. And, whistleblowers are going to be stronger than ever. I think you might have noticed in the beginning when we were talking about the number of whistleblower cases technically did go down in our, the number of FCA cases and the number of whistleblower cases did technically go down in 2020 as compared to 2019. But remember, 2020 was the year COVID hit and courts were closed. So despite the fact that courts were closed, the government was still able to get, hundreds of millions of dollars in under these False Claims Act. So the government is motivated and they are using every single resource that they possibly can. So that is our presentation on the False Claims Act. We now open.
I think we had I had a couple of questions on chat. Let's see. Okay, first question from Ken Garrison is, while there is an anti-retaliation provision, what is the penalty for an individual along with their attorney for bringing a false claim under the act? In other words, lying about it. I don't think there's a penalty under the False Claims Act for it, but in a normal court proceeding, a unfounded claim could result in sanctions, at least in these, which are federal cases primarily, under Rule 11, right, Emily? Is that
right?
Federal Rules of Procedure.
Yeah, so that's the rule, and it's a very, very high burden in order to prove that somebody intentionally brought a false claim against you in federal court, and it's very, very hard to actually get sanctions. Sanctions don't just have to be attorney's fees. The judge can award whatever sanctions he or she sees fit. But I want to reiterate what Joe was saying when we were talking about the anti-retaliation provisions. The employee does not have to be correct in their assertion that you or your company have been submitting false claims. They just have to have a reasonable belief that something weird is going on. They have to tell you about it. And then if you fire them because you're like, okay, you are a troublemaker. This is not the first time that you've come to me with something ridiculous. You're calling me a liar. You're calling me a cheat. I don't like you. I'm firing you. That can still be considered a viable anti-retaliation claim. And the courts, have designed this rule because they want to protect whistleblowers as much as possible. So they say, if they just reasonably believe that you are doing something illegal or submitting a false claim or taking advantage of the government or some way, it just has to be reasonable. It does not have to be true.
Okay.
That's scary. That's very scary.
We have another question. Ken wants to know, in the Farfield case, was this a union contract or did the union insert itself into the case to disrupt the contractor's payment of workers? Well, I looked at the decision quickly and I'm not sure it says, but I would say that it almost has to be a non-union company, because if the workers were union, it would have, there would have been a protest instantly as soon as an electrician got paid labor rate for work. The union would have had a grievance immediately. So I don't think it ever would have gotten that far. And I think this was the union's revenge against the non-union contractor in this case, and probably pretty good revenge as it turned out.
Yeah, especially because Don't unions usually have arbitration clauses? So this wouldn't have even been a case in a courtroom. It would have been in arbitration. That's my guess.
Okay.
So I've got one. So I think on one of Emily's slides, you were talking about the 4 conditions that you would have to prove to be a false claim. But going back to say a certified payroll. So a sub submits a certified payroll that you then certify yourself and pass on to the government. How can you know exactly what that person is being paid? If somebody's, should be paid $20 an hour and they're paid 19, actually, how would you be liable for knowing that dollar difference?
Well, I would say, John, in that situation, you probably wouldn't be liable because, Emily, go back to the slide about knowledge. Can you do that?
Yeah.
You have to have either actual knowledge or reckless indifference, or forgot what the third category is.
Yeah, and those tests just seem to be very broad. Like you
Well,
can
they are
easily
broad,
fall in
but
any of those categories.
to take your example, deliberate ignorance or reckless indifference. To take the example you gave, John, they say that the guy makes 20 when he makes 19. Now, you certainly don't have actual knowledge because you don't look at their paychecks. You're not deliberately ignoring it or showing because nobody complained to you about it, let's say. And you don't have reckless indifference because it's not obvious. In that case, while the subcontractor might have liability, I think it would be very difficult to make a case against you. On the other hand, if they have a guy out there and they say he's making $4 an hour, and you know darn well that in the industry, workers in that category generally make $25 and up, and you look at the payroll, you see the guy's getting, let's not say 4, but let's say he's making the old minimum wage, and you know that can't be right, and you don't ask any questions, you might have a problem. But the difference between 19 and 20, or even 16 and 20, I don't know how you would know that, nor would that would trigger anybody saying, well, you were on notice and should have figured it out.
Right. So it's got to be relatively obvious, whether it's certified payroll or a claim that you're passing through.
Right. But if the subs worker came to you and said, geez, John, I mean, these people aren't paying me what it's supposed, the required wage rate. I think at that point, if you just said, go talk to your boss, you might fall into one of these deliberate ignorance or reckless indifference categories. So, with a complaint, I think you have to be much more careful. Without one, in the example you gave, I mean, I don't see any way you would know that.
Got it. Thanks.
More questions? Going once? Going twice? Well, thank you very much. We appreciate the opportunity to be here today, and look forward to the day when we can do these live instead of on Zoom.
Thank you, Joe, and thank you, Emily. Thank you all for being here. This presentation will be available on YouTube either tomorrow or early next week. And if you would like to see the presentation again, please reach out to myself or Joe to have it sent to you. And we hope to see you this afternoon at Chantilly. Thank you all.
Thanks.
Thank you, Joe. Thank you, Emily.
Thank you, Joe. Thank you, Emily.
Thanks, Joe. Thank you.